I'm Matthew Mazur. I'm a Florida attorney, and today I would like to discuss the lessons that can be learned from the SlideBelts Inc. settlement with the United States government regarding PPP loan fraud. Some background: SlideBelts Inc. is a manufacturer and online seller of fashion accessories. They are based in Dorado Hills, California. In August of 2019, SlideBelts Inc. filed for a Chapter 11 bankruptcy. On April 3rd, 2020, SlideBelts applied for its first PPP loan with what we'll call Bank 1. On April 10th, 2020, SlideBelts applied for another PPP loan with Bank 2. The reason this information is important is because one of the financial institutions, Bank 1, that SlideBelts sought a PPP loan from was actually a creditor in their bankruptcy and knew that it was not eligible for a loan. On April 10th, 2020, Bank 1 notified SlideBelt that it had an error on its application with regard to whether or not it reported it was in an active bankruptcy. Bank 1 knew they were. Miraculously, on the application, it did not answer that question in the affirmative. SlideBelts did not want to change that application and stood their ground, saying it was not clear about what the language of that question was, and that the bankruptcy shouldn't count. Needless to say, on April 14th, 2020, Bank Number 1 formally rejected SlideBelts' application. Less than 3 hours after Bank 1 rejected SlideBelts' PPP loan application, SlideBelt submitted another PPP loan to Bank 3. SlideBelts kept the false statements regarding the status of their bankruptcy in the application with Bank 3. In the meantime, Bank Number 2 approved SlideBelts' PPP loan before Bank 3 had processed their documentation. The loan documentation that was executed between Bank 2 and SlideBelts, again falsely claiming it was not involved in a bankruptcy, was executed and finalized, and the loan was funded. This is a key issue because at the time of the signing, the president of SlideBelts knew or should have known that SlideBelt would be in default on the loan that it was signing for if it entered into a bankruptcy proceeding. On April 30th, 2020, SlideBelts filed a motion with the bankruptcy court to retroactively approve the PPP loan. In that motion, SlideBelts did not disclose to the court that it had obtained the PPP loan by making a misrepresentation in its application about the status of its bankruptcy. On June 16th, 2020, the SBA opposed this motion and Bank 2 joined in their motion. SlideBelts' first bankruptcy case was dismissed on June 30th, 2020. The SBA demanded the return of the PPP loans prior to the dismissal of that first case. On July 8th, 2020, SlideBelts finally returned its $350,000 PPP loan to Bank 2. On August 25th, 2020, SlideBelts filed another Chapter 11 bankruptcy, this time under Subchapter 5 of Chapter 11 of the Bankruptcy Code. Fast forward, on January 12th, 2021, the United States Attorney's Office for the Eastern District of California entered into a settlement with the owner of SlideBelts Inc. for the PPP loan fraud issue. In the news stories regarding SlideBelts' situation, they portrayed the owner as being proactive and correcting inaccuracies in his PPP loan application before either the lender or the government identified these inaccuracies. The problem with this portrayal is that these issues had been raised by SBA partner Bank Number 1 and were ignored or avoided by SlideBelts as it continued pursuing loans from the two other financial institutions. SlideBelts only corrected the inaccuracies in its PPP loan applications after the SBA and Bank 2 raised objections in the pending Chapter 11 bankruptcy case and demanded the loan proceeds back. SlideBelts did not disclose these inaccuracies until after receiving the PPP loan funding. It is interesting to note that SlideBelts did not return the loan proceeds to the lender at the time it acknowledged its inaccuracies or its mistakes on the application to Bank 2. It is almost 2.5 months from the time that the loan application was submitted and the loan funded that they finally returned those funds. The reason that this long fact pattern is important to follow is because it shows there are ways to mitigate and potentially avoid criminal charges in a PPP loan investigation. SlideBelts folks were not timely and even could have been considered to be less than honest in their dealings with Bank 2, Bank 3, and the SBA, and even the bankruptcy court. They were able to resolve their PPP loan fraud investigation with a civil disposition. In addition to returning the loan to Bank 2, SlideBelts agreed to pay the government $100,000 over time as a civil penalty, and that amount included the $17,500 of restitution for the loan processing fees. The lesson to learn here is, by self-disclosing inaccuracies and cooperating with government officials, PPP loan recipients who may be in a potential fraud investigation and could be facing criminal charges may be able to receive leniency from government enforcement. That is why it's important to act sooner rather than later when dealing with a PPP loan fraud investigation. I hope this extended video regarding the lessons that can be learned from the SlideBelts Inc. settlement with the government regarding the PPP loan fraud investigation has been useful. Please check out the other videos we have on our PPP loan fraud channel here on YouTube, and please subscribe to our channel and give us some likes. Thanks so much.